Welcome back to Breakfast Central. We're still looking at the Supreme Court's judgment regarding the president's power to initiate not just state of emergency, but also to suspend executive governors, democratically elected executive governors. We're joined in the studio with constitutional lawyer and human rights advocate, Inibehe Effiong. Thank you very much for joining us this morning.
Always a pleasure.
Now let's go to the implication of what this means, because on the surface, people will think, okay, the Supreme Court has said the president can do this. He did it anyway. It's one thing for it to have been done, and then we've moved on from it. It's another thing for the Supreme Court to give relevance to it, to give legal backing, which is what the Supreme Court has done by this judgment. What's the implication of this?
No, let's be clear once again.
Okay.
On the Rivers emergency, the Supreme Court has not validated it. And that is the point I want people to understand.
They refused to make a pronouncement.
They declined. The Supreme Court didn't make a pronouncement.
But doesn't that fall into the category of this judgment that was given here, to say that the president can, of course,
in terms of
enforcing his powers in Section 305, and then he can suspend democratically elected governors?
Well, like I said, if you read the way this printed summary, what the public has, what is available, the way it is couched, the Supreme Court was very careful. The learned justice of the Supreme Court who read the summary, my Lord Honorable Justice Mohammed Idris, a jurist of profound intellectual capacity, who some of us have been privileged to appear before, even while my Lord was in the lower courts at the Federal High Court in Lagos here. What the justices did was to give some sort of theory, constitutional theory, because they declined jurisdiction. Take note of that. When a court declines jurisdiction on a substantive matter, whatever opinion is rendered subsequent to declining jurisdiction is what we call obiter dicta. It doesn't have coercive force. Now, can the president suspend a House of Assembly? Can the president suspend a governor? The Supreme Court seems to say, well, that even in declaring emergency, there are certain safeguards. What I find very interesting is that the Supreme Court even went further to state the circumstances in which this emergency may be declared. And I find quite interestingly that, in my view, I haven't seen anything to show that in Rivers State those circumstances existed. It has to be in situations of war, natural disasters, and so on. And I didn't see, yes, if you check page 8, for example, under specific conditions, including war, imminent danger of invasion, actual or threatened breakdown of public order and safety, or other public danger threatening the exercise, the existence of the Federation. I didn't see any of these conditions in Rivers State. So if the Supreme Court had actually gone into the substantive matter, I am tempted to believe that they would have pronounced this particular emergency unconstitutional.
So
but the government says they anticipated a breakdown, that Rivers State was heading towards...
Because of the bombing of pipelines.
Yes, and the political issues there.
No, there was no... The excuse of the president was untenable. If the president
so
was...
if you're using this as a threshold...
Yes. No, I'm saying that assuming what the president said had any stratum of logic, then most states in Nigeria should be under emergency today. As I speak, Kogi State shouldn't have a governor. Why is there a House of Assembly in Kogi State today? Why? With the kidnappings, the killings? So if we are speaking about actual imminent breakdown of law and order, there are states in Nigeria, as we're having this conversation, that law has actually broken down. Their schools have closed. But many schools in the north are no longer opening.
Mass kidnappings of children.
Yes, so why are the governors still in office? The president acted in bad faith. The president didn't act in the public interest. The emergency in Rivers State was partisan. It was political. It was a hit job to empower Wike and castrate Fubara. And we have seen the effect of that. He has now joined the president in standing on the mandate.
Speaking about that, I mean, let's talk about... So I wanted to ask you about the Supreme Court's... In fact, I have two questions in mind, but let me go back. I'll come to talk about Fubara in a bit. You've shared with us now that the Supreme Court declined jurisdiction to speak about the matter in Rivers State. So where does jurisdiction now lie? And what's the fate of that? Is that an issue that will then be brought up again in a separate suit?
So there is another aspect of this where the learned justices stated that on the question of objection, right? If you check page 4, upon a careful examination of the plaintiff's questions and reliefs, it is clear that their grievance arose principally from the declaration of a state of emergency in Rivers State, the suspension of the governor, deputy governor, and House of Assembly of that state, and the appointment of a sole administrator. However, none of the plaintiffs represents Rivers State, and neither did they establish any authority to litigate on his behalf. On his behalf. So the Supreme Court said the emergency did not take place in any of these 11 states. My own concern, with proper respect to my noble lords of the Supreme Court, is that going by the precedent in the case of Plateau State and precedent of the which was decided during the Obasanjo proclamation, the Supreme Court held profoundly so that the case could not have been brought at the time without the approval of the sole administrator, because he was the de facto, he was the one in charge of the administration of the state. So I am submitting to you this morning that there was no way in fact or in law that Rivers State, under the leadership that had been suspended, could have brought this action. So
they were gone already.
Maybe Fubara, I had in my previous interview on this same station, advised that Fubara was in a better position to bring that action, except that he couldn't have approached the Supreme Court. He had to go to the Federal High Court. Now, one other quick point. In the printed summary that we have, the Apex Court made a very significant finding that the state of emergency, upon being proclaimed by the president, must receive the sanction, that is the approval, of both chambers of the National Assembly, voting by 2/3. In the case of the Senate, the Supreme Court highlighted the mode of voting, mentioned voice votes, subject to the right of a member to object. I don't know if you can determine percentage by voice votes. Is it about who is screaming louder? Is it about who is more vociferous? How do you determine who 2/3 by voice votes? The nays and the yeas. So it will not become a competition about who is louder. I don't think it is possible. But my Lord said that based on the standing orders, which is correct of the Senate, that they can actually vote by voice votes. And then the member has the right to object if that member feels that the verdict of the presiding officer is not reflective of the opinion of the majority. I have reservations about using voice votes to determine numerics. I don't think it's possible. Now, the Supreme Court also said they can use electronic voting. They can also do head counts. In the case of Rivers State, both the Senate and the House of Reps elected to vote by voice vote. And in the decision of the Supreme Court found that in the House of Reps, by their standing orders, they could only have voted, I will refer you to page 12. In the House of Representatives, Order 16 of the Standing Orders, 11th edition, governs consideration of proclamation of emergency. Voting modes are provided under Order 11, significantly Order 11.6, empower the Speaker, where a matter of national concern, to order a division with votes recorded by name, constituency and choice, and published accordingly. A proclamation of a state of emergency is unquestionably a matter of national concern. This is the Supreme Court saying that in the House of Reps in particular, they could not have voted by voice vote. But in the proclamation in Rivers State, it was a voice vote that was used. So on that score, on that premise alone, what President Tinubu did in Rivers State is clearly unconstitutional. It is illegal. So this is even on the basis of the opinion of the Supreme Court. But as I said, my Lord declined to speak specifically about the Rivers matter. My Lord seems to have only gave a broad opinion on the concept of a state of emergency. So I am submitting to you that whether on the basis of the reasons that Section 305 envisages or on the procedure adopted, this particular emergency in Rivers State was illegal. Now, one other curious point. The Supreme Court also said that the proclamation has to be subject to legislative approval and oversight and judicial oversight. Ibokibas, who has now been rewarded handsomely with an ambassadorial position, has refused to submit himself to oversight. Not only did he treat the National Assembly with scorn when they tried to interface with him, he has also bluntly told the House of Assembly that he cannot recognize the authority. He cannot submit himself before them. And the Amawele House have come out to accuse him of misconduct. Their billions were frittered away from the River State account. So what I am saying is that while it is good that my lords have made the point that state of emergency has to be subject to judicial and legislative oversight, this is a live example of failure of both judicial and legislative oversight on the fact that for the 6 months Ibas was in office, the people of River State have not been told how their resources were spent. They have not been told how contracts were awarded. So you cannot say that you will bring in a military man, somebody with a military background, to come and take over the governance of a state for 6 months. And nobody can ask him questions. He was even making ludicrous appointments. Nobody is able to ask any questions. So I am saying that we need to rethink our constitutional system in this country.
So many issues to unpack, but we have some sorts of breaking news now. We'll connect live with our correspondent in Kano State, who's on standby to give us reports on a developing story, Emmanuel Bagudu. But what we're hearing now is that we lost connection with him. We'll get back to him in the course of our conversation.
Okay, I want us to still now come back. You've talked, a key part of your statement is how the Supreme Court declined to, speak about what's happened in River State and to give a judgment regarding the legality or otherwise of the suspension in River State. Now, how important is this going forward? Seeing that the person that you were fighting for, or the person that people were fighting for.
We didn't fight for Fubara.
Well, true.
Yes.
It wasn't about Fubara. It was about
for the rule of law.
Yeah.
It's about
the rule of law. How would you say, first of all, how do you feel about how things have panned out in River State with Siminalayi Fubara having now linked himself and aligned himself with the ruling party? But sleep on that for a bit. Let's connect with our correspondent, Emmanuel Bagudu. Good morning, Emmanuel. Where are you and what is the cause of the protest? Yes, we can. Please go ahead. All right. We will try to reconnect with Emmanuel Bagudu when we are done with this conversation. But now, back to you. Let's talk about why this is important and your thoughts regarding how things have played out in River State.
It's very important because the question Nigerians should ask themselves this morning, what is stopping Tinubu from waking up from the wrong side of the bed one morning to remove the 36 state governors? Is there anything hindering him? So, look, I'm a minister in the Temple of Justice. All I can say is that the court pleases. And I say that the court pleases on these judgments. I can only bow to the Supreme Court. I cannot stand and challenge the Supreme Court. I cannot even criticize the Supreme Court. I have read the decision of the Supreme Court. And look, I'm not in a position to come and say that what the Supreme Court has said is wrong. No, God forbid I should come and castigate the Supreme Court. All I can tell you is that the implications of this for our country is something that we have to think about. So there is need for an urgent constitutional amendment.
So are there constitutional guardrails as we speak to prevent this sort of situation from happening? Because people might be thinking that, the president can't wake up and, do that. It will be... But you see what's happening in the United States, for example, where people never thought that a president of the United States will say some of the things or carry out some of the executive orders and things that he's doing now. So there's always the possibility. That's why the framers of the Constitution would, give certain guardrails to prevent total impunity and, dictatorial tendencies. Constitutional
guardrails are only effective in a country where public officers respect their oath of office. We have a National Assembly. Did they intervene? The answer is no. Do they even have the decency to ask how Ibok spent money? The answer is no. This is an local National Assembly, and you are talking about constitutional guardrails. in a country that the IG, I think just yesterday, barely 24 hours ago, came out to tell Nigerians that despite a lawyer, I'm giving you an example of failure of our institutions of government. There is a case between the Nigerian Bar Association and the police in court on tinted glass permit. The counsel to the police made an undertaking in court that they will maintain the status quo until the case is determined, which was the freezing of the enforcement. On the basis of that undertaking, on record, NBA withdrew their motion for interlocutory injunction. The court adjourned the matter for judgment. Instead of awaiting the judgment, the IG decided to give his boys Christmas bonanza by saying he will resume enforcement. I'm saying this is the police, the primary law enforcement agency. The head of that agency is now going on record to show his disdain for the rule of law. That is not a country that you can speak about constitutional guardrails. So we have a situation quite tragically in Nigeria where institutions that are supposed to safeguard our democracy, that are supposed to preserve the rule of law, are the ones raping the constitutions, are the ones desecrating the rule of law. Sometimes you even go to court, and you find it very difficult to even get judicial intervention. And even when the courts intervene, the executive flouts orders of courts. So this is a very, very bad situation for our country. We need to really rethink the direction that we are going. Because the way it is, the president is becoming a monarch. We are going through, it looks like we are transcending towards a monarchy. What is stopping Tinubu from doing whatever he wants to do today? I mean, look at, why do you think all the governors are defecting? Is it because the APC has done so remarkably well? It is because even they themselves do not believe in the country. They don't believe in our systems of checks and balances. They don't believe in the rule of law. They don't believe in a multi-party democracy. So we need to be, I'm saying that, looking at this judgment, there is need to redefine our constitutional system, the direction we are going. The Supreme Court also made a finding, by the way, that Nigeria operates a constitutional system of government based on federalism, federal system. No arm of government, no tier of government is superior to the other. That's what the Supreme Court has said, but is that really the case? In some states, guess what? In some states, the judiciary is barely functioning, including Imo, because governors have chosen, and
there's barely separation of powers.
There is, I mean, you could clearly see when vehicles are purchased for judges, they call the media. But when vehicles are purchased for commissioners, no governor shows it to the media. Why is it so? The judiciary has to also think about its own independence.
But do you think the judiciary has to save itself? Let me just read something to you. This is the latest information. This time, let's go to Akwa Ibom State. The speaker, I don't know if you've heard about it.
It's the clownish comments the gentleman made.
Akwa Ibom House of Assembly,
yes.
Talking about Udeme Otong. Now, he said this, and I quote, all of the 26 House of Assembly tickets are already in my pocket.
Akwa Ibom,
I single-handedly negotiated for them.
Yes.
No one else did. I will personally, he says, choose who becomes a House of Assembly member and hand the tickets to the person from my pocket. This is someone who understands the law and is openly saying
he's a lawmaker
in public as a lawmaker. What does this tell about Nigerians?
One of the things, one of the issues we must have is serious, and I'm not joking here. I don't want you to take what I'm about to say as a joke. One of the issues Nigeria as a country must seriously debate is insistence on those seeking elective offices to undergo a drug test. That kind of statement should be a product of intoxication. Someone had marijuana in the night and woke up in the morning, he's so high, he cannot see well, and he begins to talk carelessly. Akwa Ibom and it's my state, by the way, so it's personal to me. Akwa Ibom is a clear demonstration, a vivid example of how institutions of governance have failed. It didn't start with Umoino. From the Akwa Ibom years, Akwa Ibom has not had any semblance of opposition in the governance of the state. So when you have a speaker, who, by the way, I don't even know how many people in his constituency know him. In fact, it was when I saw the news, I had to go and check who is the Speaker of the House of Assembly. I don't know the gentleman. I'm not sure how many people know him. So, but he comes out and he speaks so carelessly. He speaks with so much insolence.
Colleagues, his peers.
He said the Assembly tickets, 26 House of Assembly tickets are already in my pocket.
Finally, Inibehe, before
I was expecting that.
He's not a serious person. I think the public should disregard what he has said.
If you can, in a minute, we'll really appreciate it because we're out of time. Senate President Godswill Akpabio yesterday in the plenary did talk about involving the NSA and the DSS in dealing with people who carry rumors of fake debts. It was reported that former President Yakubu Gowon passed over the weekend, and we've also seen a few politicians' names banded. What do you make of that? Is that the statutory responsibility of the DSS and the National Security Advisor?
They are telling us that those institutions have become redundant. Because, I mean, I think Akpabio may be trying to indict Ribadu, because if Ribadu is serious with his job, look at the killings and kidnappings. Why is he not bothered about that? He wants the National Security Advisor of a country to be chasing people that are spreading rumors that somebody has died.
All right.
This is just a clownish show. They should stop embarrassing our country. If they don't have what to do, they can simply resign. What is the business of the NSA with spreading rumors that somebody has died?
All right. Inibehe, thank you for joining us. Just to clarify, the clownish show he's talking about is not our show. It's about what's happening in the red chambers. Well, thank you for joining us.
It's always a pleasure.